This is an overview for civil litigation. I don't want to spend too much time here again on this overview matter. Civil litigation. This just involves rules or procedures that regulate the conduct of civil proceedings in courts. As simple as that. Just the rules, the procedure that regulate the conduct of civil proceedings in courts. That's just what you'll be learning in civil litigation. Everything that has to do with civil proceedings in court. So for you to commence an action in court, in a civil court, there are factors to consider. You talk about the courts to go to. Talk about that's now okay, which court has jurisdiction, talk about the appropriate party to sue, the service of court processes, the modes of commencement of action, the pleadings, the interlocutory applications, the third party proceedings and interpreter proceedings, the pretrial issues, the summary judgment procedure, the trial evidence and examination of witnesses, the closing address and judgment, the enforcement of these judgments, and then if there's any application pending appeal, and then the final part, which is the appeals. So we have different sources of civil litigation. We talk about the constitution. For the constitution, it talks, how it provides for the courts. You can find the creation of courts in the constitution. You can find the power of the court in the constitution. You can find the authority to make rules in the constitution, which is conferred on the Chief Justice of Nigeria. You can find the rules on this civil litigation, like Section 36 on fair hearing. You can find the enabling law for some of the procedural rules of court. So after constitution, we have statutes creating courts, like the Court of Appeal, for instance, has its own act. The Supreme Court has its own act. Then we now have rules of courts. So what are the objectives? Uniformity and stability of practice, speedy trial, rules-based precedence, consistency of practice. These are the essence. So we have different courts. And then another source is the special statute on procedure. Maybe we talk about the Evidence Act, the KAMA. At the end of the day, all of these are intertwined. The Matrimonial Causes Act, because when you go to a civil court, you can see that your judge sometimes will sit on marital matters. When I did my externship, there was about once or twice a marital case. It was even virtual, so we were all there. The woman, the man, everybody was virtual. They were not together or different places, but the proceeding was held virtually. So another source is practice direction. So then we have ADR, alternative dispute resolution. Nowadays, in your RPC, rules of professional conduct, rule 15.3d would always advise that a lawyer first of all suggests out of court settlement before we now start going to court, because at the end of the day, whether you like it or not, litigation, it takes time, it wastes time. When you can just do something out of court and good to go. Even our judge, where I did my externship, she kept advising us, make sure you first of all suggest litigation, otherwise this that. I look at it, a lot of cases unattended to. She kept talking about it. So what is the advantage of ADR over litigation? Somehow it is cheaper along the line, because litigation, sometimes in court you hear that one case has been in court since 1976. That time they've not even thought of giving birth to me. So you hear that one case has been there. So imagine since that time, paying appearance fee. Since that time, you are paying all sorts of fee apart from appearance fee. You are just spending money. What's the essence? What's the need? Then it is faster. It leads to preservation of relationship between the parties. Like it will be like a win-win situation, not court where there's always a loser. Then there will be privacy of the parties. It's less formal. Then it's not the one that you just be in the open court. Then there's the involvement of parties, of both parties, unlike in litigation. So disadvantage, it leads to the impediments to the development of case law. It is expensive in the short run. Like I said, yes, when I said that the advantage is cheaper, it's just because of the time of litigation. So it is expensive in the short run. There's a lack of binding force, although now there's a new arbitration and mediation acts of 2023, but they just started it. They just started using it. So for us, our set, we were taught, but we're not really taught because it's still new. So maybe your own set now, they'll teach you very well. Maybe they will also set questions on it. Good luck. Then there's difficulty in finding qualified personnel. Sometimes this alternative dispute resolution, it's not just anyhow person that should do it. So that's another disadvantage. So, but then it's not in all cases that alternative dispute resolution will apply. For instance, in capital offences, it cannot apply. In election processes and petition, it cannot apply. For matrimonial causes, when it has to do with breakdown of marriage, it cannot apply. For matters that requires evidence to be proved, like declaratory relief, it cannot apply. Disputes relating to building interpretation of law, it cannot apply. For cases of urgency, it cannot apply. So what are these courts with civil jurisdiction? What is jurisdiction? In case you don't know, it's just the power of the courts to be able to decide on a matter. That's just what jurisdiction is. Is this court able to decide on this matter? So, in case of Madukolu and Ikemdilim, it provides 3 conditions that must be in existence before the court can be said to have jurisdiction. Number 1 is that there must be constitution as to qualification and the numbers of members of the bench, and no member is disqualified for one reason or another. Then 2, the subject matter of the dispute must be within the jurisdiction of the courts and no feature in the case which prevent the court from exercising its jurisdiction. Then 3, the case must have been brought to court in accordance with due process of law. Those are just it. So what are the types of courts? Supreme Court. I don't want to bore you with this. I will just tell you the sections, because if I start saying this, we'll not leave here today. The Supreme Court, because you have to know the establishment, the composition, the appointment of the head and other justices, the qualification, the vacancy of office, the removal of office, what will happen. And you have to know them, because in a scenario, they can ask you a question. They can bring up a matter that, oh, this person went to the Supreme Court. Is that the right court to go to for such matters? So that's why you need to really know these ones. So the Supreme Court, you can find that in section 230 of the Constitution of the Federal Republic of Nigeria. You know that the Supreme Court has original jurisdiction. That they can settle matter between federation and states, state and state. And then they can settle matters between National Assembly and President, National Assembly and State Government or State of the Federation, and the National Assembly and State House of Assembly. So then they also have appellate jurisdiction. That's decision in any civil proceeding in which the ground of appeal involves question of law alone, interpretation or application of the Constitution, provisions of Chapter 4 of the Constitution. Then decisions on any matter, whether any person who has been validly elected into the office of the President, VP, Governor, DG of a state under the Constitution, if it has to do with the term of office of the President, Vice President, Governor or Deputy Governor, if it has to do with the office of the President, Vice President, Governor, Deputy Governor, whether it has become vacant, whether it is now it has ceased, and then for other matters that will be described by the Act of the National Assembly. So just look at section 230 of the Constitution, you'll find it there. Then we have the Court of Appeal from section 237. They also have original jurisdiction, they also have appellate jurisdiction. Then you look at this Court of Appeal, yes, they take appeals, as the name implies, from the Federal High Court, from NIC. NIC is National Industrial Court, mostly about labor matters. So then we have the Federal High Court. You can find that from section 249 of the Constitution. Then know the jurisdiction of the Federal High Court. Section 251 provides for the original jurisdiction. They are about 18 or so, about 19 of the original jurisdiction. So if a case comes up now, in a scenario, they can say, oh, drug, either maybe they can use drug or a case that relates to custom and excise duty, and they will not tell you that, oh, the person went to Supreme Court. Is that the Supreme Court have the jurisdiction? You should already know that it's supposed to be the Federal High Court that will have the jurisdiction. So know the original jurisdiction of the Federal High Court is in section 251. About 18 of them is there. They also have appellate jurisdiction. They can hear and determine appeals from magistrate courts, appeal commissioners under the Companies Income Tax Act, Immigration and Correctional Services Board. Then there's the High Court of States. You can find that from Section 270 of the Constitution. There's the High Court of the Federal Capital Territory, Section 255 of the Constitution. So that's about it. There's National Industrial Court of Nigeria. That you can find in Section 254A of the Constitution as well. There's the Sharia Court of Appeal of the FCT from Section 260 of the Constitution. There's the Sharia Court of Appeal of State from Section 275. There's Customary Court of Appeal of the FCT from Section 265. Don't feel overwhelmed though. It's all part of it. It will pass. There's the Customary Court of Appeal of a State. There's the Magistrate Court. And the Magistrate Court, they have grades. Also know the grades. There's the ECOWAS Community Court of Justice. Just look through your constitution from Section 230. If maybe you can use one evening or one afternoon or maybe weekend, just pick your constitution from Section 230 and go through these different courts. So that should be all for now. Thank you. Then I should add this for that Federal High Court, because if you look at Section 251, they will say, you will see that it has bank matter should go to the Federal High Court. However, if it is between a bank and an individual customer, the High Court can also share the same jurisdiction with the Federal High Court. This was what was established in the case of NDIC and Okem Enterprises Limited. So, but if it's between bank and bank, can then fully take it to the Federal High Court. But if it has to do with a bank and individual customer, like a bank now and you can take it to the state court, the state high court. They will also have jurisdiction over it. So next class we'll move to parties. We're looking at parties to civil action. So this is where starts the main. Thank you.